Good morning.
Hold on, please. We want to get you on tape. All right, let's proceed.
Good morning. My name is Michael Caneb. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. With me is Assistant District Attorney Robert Bender, who co-wrote the two briefs, and also Assistant District Attorney Christopher Tarrant, who tried this case. I'd like to begin by addressing the judge's order here, which was the subject of the Commonwealth's appeal, because it raises certain statutory and common law questions that I think the court needs to address in addition to any constitutional questions. This case is before the court on the Commonwealth's appeal of two rulings by the trial judge. First, that she lacked authority to follow the individualized sentencing procedure required by Miller, and second, that she could only sentence this defendant convicted of murder in the first degree as if he'd been convicted of murder in the second degree. Those rulings were error. The judge had authority, even if not specified in the statute, to impose life without parole after a Miller hearing, as the Eighth Amendment allows, or to impose life with parole for a first-degree murder conviction if a Miller evaluation required that lesser sentence.
But nothing else? No term of years, in your view?
No, Your Honor. I think it's quite clear that the legislature intends that murder, whether it's first degree or second degree, is punishable by a life sentence. And nothing in the Miller decision changes that. And I would also just point out that to the extent that argument has been raised by some of the amici or by defendant, it has to confront Graham versus Florida, in which the Supreme Court held that a life with parole sentence could be imposed for non-homicide offenses. So I don't see where the authority would be that life sentences were simply off the table somehow after Miller. No act of the legislature is required for the court to follow the Miller proceeding. A court has inherent authority. Courts possess all power necessary to the performance of their duties. That's recognized in common law and also in Chapter 220, Section 2. Because the ability to sentence this defendant following his conviction was essential to the court's ability to decide the case, it was one of those occasions that the court has said which is proper for the exercise of the inherent authority, an occasion not provided for by established methods. Beyond authority, I would suggest that the judge had an obligation to sentence the defendant as the legislature intended, where that was constitutionally permissible. The defendant was tried and convicted of the most serious offense in the Commonwealth, and the legislature has specified a specific penalty. Where the legislature has enacted a statute that faces a constitutional limitation, the court is obliged, if possible, to find a method of applying that intention consistent with the Constitution, and the Supreme Court has handed the judiciary exactly the device needed to do so. In the Commonwealth's brief, we have reviewed some other circumstances where judicial constructions have been used to remedy statutes. We reference the development of blood warrants. We reference the disorderly persons statute. So I don't think it's controversial that the judge had the authority to conduct the hearing that Miller requires, and it's not seriously challenged by the defendant or the amici. The second order issue that's presented by the discretion that Miller introduces is what is a parole-eligible alternative, which has to be considered for a murder one conviction. Now, we know what a sentence for murder in the second degree is. It's a life sentence with parole eligibility at 15 years. A parole-eligible sentence for murder in the first degree must respect the legal distinction between the crimes. And so it was error for the judge to conclude that if she wasn't able to impose the statutory sentence, the only alternative she could possibly impose was a sentence for murder in the second degree. It offends the principle of graduated punishments that's in the murder statute and that's in criminal statutes generally. The legislature has specifically instructed that where no punishment is provided, which would literally be the case if the judge was obliged to impose a parole-eligible life sentence for murder in the first degree. In that circumstance, the judge is instructed to impose a sentence that reflects the nature of the crime and common usage and practice in the Commonwealth. That's a statutory recommendation, a statutory directive in 279, Section 5, that merely reflects the common law authority of the court. It is necessarily a comparative determination, And for that reason, the judge was mistaken to believe that she was unable to impose a sentence stricter than the appropriate sentence for murder in the second degree.
So what is the limits here? Could the judge say life without parole, but not eligible for parole for 70 years?
Yes,
Or
I mean,
not eligible for
I think if
life with the possibility of parole, but parole eligibility only begins 70 years from now. Could a judge do that under your theory?
well, it's clear that under Miller, the judge could deny parole altogether. So the question would be whether, having concluded that that the sentence of life without was inappropriate, because that's what you'd have to conclude, I guess, if the judge did not impose life without. The question would be whether it was an abuse of sentencing discretion to provide something that was possibly effectively exactly the same sentence she already determined wasn't appropriate. And that's essentially addressed in the Iowa cases that were referenced in the prior argument. Our only argument here is that the judge was improperly limiting herself to a parole eligibility at 15 years, which is provided by statute in Section 133A, but that very section says that it's not intended, that it may not apply to a murder in the first degree conviction. The legislature has never kept parole eligibility at 15 for any other crime besides murder in the second degree and certain other unusual non-homicide crimes, and the legislature has never said that if the Eighth Amendment requires parole eligibility for a murder in the first degree conviction, the term of initial parole eligibility may not exceed 15 years. So it's an open field, I guess I would say, that the court can write on. If there are no other questions on this, if there are no other questions on the statutory question, I'd like to address the Article 26 argument. There's no basis to conclude that Article 26 categorically prohibits a sentence of life without parole for this defendant, or that Article 26 means anything different from the Eighth Amendment. In fact, the signs point all in the other direction, that the protections under the two provisions are identical. Just how extreme the defendant's position is becomes clear when it's considered in relation to Miller. Miller has already settled that the Eighth Amendment forbids sentencing juvenile offenders indiscriminately to life without parole. The defendant, therefore, has to establish that there's something in Article 26, something identifiable, that prohibits that sentence for the individual juvenile defender who's been distinguished in the way that Miller says individuals must be. That is, it must be impermissible for any defendant convicted at trial of murder in the first degree and found to be irreparably corrupt after a Miller hearing in which the sentencer has considered all of the available mitigating circumstances. In effect, the defendant and the amici are arguing that Article 26 prohibits that sentence even in the situation of a calculating, brutal murder with multiple victims, even after consideration of all the mitigating evidence.
But it doesn't the logic of Justice Kagan's decision, where she essentially said, we don't need to reach the issue of whether it is possible to have life without the possibility of parole, but we expect it to be very rare. But isn't the logic of her reasoning, which says these are still yet to be fully formed individuals, doesn't that dictate that a yet to be fully formed individual cannot be irreparable?
Well,
And therefore, as a matter of constitutional law, it would be cruel and unusual to declare a not fully formed person to be irreparably corrupt.
Well, I think Miller has to be read, Your Honor, in the context of Roper and Graham. They all use a similar balancing, where those cases which consider punishments in different contexts, different alternative punishments, they balance the severity of the offense in question versus the consequence of possible error. Okay. In the situation of Miller, you have the highest severity of offense, it's murder. You have a diminished consequence of possible error in the sentencing because you're not dealing with with the death penalty. Miller concludes what Graham said wasn't possible, in a sense. It turns Graham's language back on itself. Graham had said that it's very difficult even for professionals to distinguish between the irreparably corrupt and the defendant whose crime reflects a transient but unfortunate immaturity. Miller says, in fact, you can make that distinction. And the reason you can make that distinction is because you're dealing with a murder case. That weighs in the balance for the judge's finding. The facts of the crime weigh in the balance. In addition, the fact of the murder automatically moves the appropriate penalty into a higher category. The problem in Graham was that you were making that distinction and you weren't in you were dealing with non-homicide crimes. You were in a category that traditionally doesn't carry as heavy a punishment. Where murder is the crime, Miller has concluded that it may be rare, but after a hearing, the judgment can be made. And in fact, what's being judged in the Miller hearing, after considering all the facts of the crime and any mitigating evidence and any personal characteristics of the defendant, is that, in fact, this defendant is not capable of change, that he was not particularly susceptible or unreflecting in his crime. He is, in effect, not a youth, as that term is used generally by Graham and Roper.
If I understand you, and this is a slightly different take on this, you talk about this finding that someone is irreparably corrupt, and without that finding, they are not exposed to life without the possibility of parole, right?
I'm not sure I would say that. I would say by being convicted on a jury verdict, you are exposed to that penalty, Your Honor.
Well, but you cannot be sentenced to life without parole unless there's a finding that you are irreparably corrupt.
Your sentence violates the Eighth Amendment unless the judge...
My question goes to who should make that finding if that finding exposes you to a much greater sentence? Isn't that an Apprendi question? Shouldn't that be made by a jury?
I don't think that Miller conceives of it as an Apprendi question, which is the first answer. I mean, Miller clearly says throughout the decision, a judge or a jury, a judge or a jury, and uses the term sentencer when she gets tired of using that alternative. We do touch on this in the Commonwealth's brief. In the main brief, we've cited to Elaine, which is a recent Supreme Court decision, which states that broad sentencing discretion informed by judicial fact-finding does not violate the Sixth Amendment. So what we're really talking about here is two different issues. We're mixing an Eighth and a Sixth.
Perhaps, but if what I understand the court to be saying, a person under 17 or under cannot be sentenced to mandatory life without parole unless they are found to be irreparably corrupt. And so that finding exposes someone to a far greater sentence.
Well,
Am I wrong?
No, I would argue that what exposes the defendant is the jury verdict of murder in the first degree, and there's a secondary question. So the Sixth Amendment concern is satisfied by the jury verdict. There is, in fact, no additional fact that the jury has to find to expose the defendant to this penalty. There is a secondary question, which is the Miller question, which is an Eighth Amendment question. Is the punishment that the defendant was on notice he was exposed to, and that all of the elements have been found for, is that in the individual case cruel and unusual punishment?
But it's different from being knowing that you're exposed to it than finding the fact that it is going to apply to you. I mean, it seems to me, and maybe I'm not getting this correctly, but if you look at Southern Union about fines needing to be jury, all right, the defendant knows that it was exposed to a fine of up to, millions of dollars. The finding that indeed that would be applied in that case, the court said needed to be by the jury.
Well, I guess we read Miller somewhat differently. I think Miller's quite clear that this is sentencing discretion, that it falls within the broad range of sentences that a judge can impose, that there is no particular, I don't think you can point to a particular fact. The opinion uses the term irreparably corrupt. I take that as a summary for a discretionary judgment, that the penalty that was provided in statute and that's supported by the jury verdict is appropriate in this individual case, and that there aren't mitigating circumstances that ought to reduce that. I just have a minute or so left. I would just like to point out that the defendant has not pointed to anything in Article 26 that suggests the analysis really is any different than under the Eighth Amendment. There's no ground to diverge from the federal Constitution. If one makes a review of the indicators this court has traditionally relied on, and I did take a look at Chief Justice Ireland's article as well as Chief Justice Wilkins' article, there's no difference between the text of the two provisions, no difference, no evidence in the Massachusetts.
There is. I mean, you just don't think and or make any difference?
I think there's an abstract argument they do, Your Honor. I think you have to fill the two terms to know, with something practical, to know if cruel means something other than unusual. And I don't think there's any Massachusetts case law that establishes that those are two terms so that it broadens them by putting in or. It's a tall order here that the defendant is asking for. A constitutional ban would require the court to conclude that Article 26 prohibits what it did not in 1982 when the court decided Judicial, that it prohibits life without parole even after an individualized hearing that's sufficient for imposition of the death penalty on adults under the Eighth Amendment and presumably under Article 26, given the way it was amended. All of this would have to be made against a 30-year backdrop of no authority contradicting Judicial, no other decision finding Article 26 more protective than the Eighth Amendment, and the legislature's adoption in 1996 and their readoption by the acts of two houses not yet enrolled in law of the automatic transfer provision in 2013, following the Miller decision. That's a very tall order to overcome, and I don't think that the showing has been made that Article 26 requires it.
Thank you, sir.
Thank you very much.
Good morning. If it pleases the court, Barbara Cabin on behalf of Marquise Brown, and with me today is Jim Boudreau. Let me start by saying a lot has changed since 1906. Juveniles are now constitutionally different from adults for purposes of sentencing. And what the Commonwealth is asking this court to do is to basically draft a whole new statutory scheme that would allow a judge to, in fact, decide whether there is discretionary life without parole, life with parole with sentencing options before parole eligibility ranging anywhere from 15 to 25 to 35 years, and to basically then figure out the contours of what that sentencing hearing would look like or the parole hearing would look like. And basically, there's no basis in precedent for you to take that type of action. In fact, historically in the past, when you've been faced with unconstitutional sentencing schemes, you've actually looked to the next most serious offense and applied the constitutional sentence that was available. And that is what we're asking the court to do.
Well, Miller certainly did not say that life without the possibility of parole was unconstitutional. It just said you had to have an individualized hearing. So why don't we just do that?
Absolutely, but what they also said, as you noted, is that, in fact, it's the rare, uncommon juvenile that would be subject to that penalty.
So it's a high standard.
With a very high standard. And as the Commonwealth actually admitted in its brief on page 44 and 45, it would be their burden to prove that this was the exceptional juvenile. So you would have to somehow factor that into your statutory scheme. And therefore, I agree with you 100% that it would definitely raise Apprendi issues. And there would have to be notice at the time of the indictment that that was what the Commonwealth was going for, and it would have to be all the way through. It would be a special circumstance.
Do you take the position that under Article 26, or maybe even the Eighth Amendment, I don't know, do you take the position that a mandatory sentence, I understand your argument about Section 2 as it currently stands, but let's say the legislature is, we agree, the legislature is now figuring out what does it want to do about juveniles. Do either of the constitutional provisions prohibit a life sentence with parole eligibility, in your view? A mandatory life sentence with parole eligibility?
In terms of what Miller says, if it's a mandatory sentence of life with parole, because it's mandatory, I would say that that would be challengeable under Miller.
Because it's not taking into
mandatory.
account the factors of
Absolutely.
use.
On page 2466 of the Miller decision, Justice Kagan actually says, a criminal law that fails to take into account the youthfulness of the defendant is fatally flawed. I mean, it's there in black and white. She says it. Now, part of what Miller did, as Attorney Keene mentioned, is that Miller did two things. It said mandatory life without parole is off the table, so it constricted what was available. And then it said you have to have this individualized sentencing hearing. And therefore, she expanded what must be available, a term of years, life with parole. Life with parole could still stay on the table, but it has to be part and parcel of a range of sentencing options. And if you're going to add life without parole to that sentencing options, then it raises the Apprendi issue. But right now, we have no statutory scheme that allows you to get there unless you decide to make up a new statutory scheme that includes discretionary life without parole, life with parole, and then they want you to add all sorts of different definitions of what life with parole means.
You're just asking us to make up a different legislative scheme, aren't you?
No, I'm asking you to drop down to the constitutional penalty that is now still available under our existing statutory scheme. That's the lesser offense of manslaughter that provides under Section 13 of 20 years maximum. I know that makes everybody nervous. They say, well, it's the most heinous crime allowed that we have here. Murder is the most heinous crime, and is 20 years sufficient? Well, let me put in the 20-year sentence in some sort of context.
But well, let's assume for a moment there are juveniles right now convicted of second-degree murder serving life sentences. So you're saying under Miller those also are in jeopardy?
The second degrees?
Yeah.
I think that there will be questions about the mandatory sentencing on the second degrees at some point down the line. I can't pretend there won't be. I think Miller raises the issue that there has to be this individualized sentencing hearing that takes into account the special characteristics of the juvenile, the diminished culpability.
Let's say the statute, it's an aggravated rape statute, and it's a 15-year minimum, maximum life. You're saying the 15-year minimum wouldn't apply to a juvenile because that wouldn't take into account, there's no minimums can apply, no mandatory minimums can apply?
First of all, let me point out that that juvenile would be in juvenile court. He would be.
No, he's been. Go ahead.
We don't have transfer. You know, the only kids who are automatically transferred are those charged with murder 1 and 2. Everyone else is subject to the YO adjudication of delinquency. At first, they get arraigned on a complaint, then they get indicted, and then the issue is, okay, they're youthful offenders. And what does the youthful offender provisions provide? Actually, this sentencing discretion. DYS to 21, DYS to 21 with an adult suspended sentence, or any adult sentence allowed by law. There is a range of sentencing options that allows the judge to take into account all of the developmental factors, the role in the crime, the severity of the crime, and make an appropriate sentencing decision. As this court said in 2012, there's nothing more important than the sentencing that judges have to impose, and they know how to do it. But they need the range of sentencing options at their fingertips. And right now, our statutory schemes don't provide it except under the manslaughter statute, because there is discretion. There, the judge can take into account all of these factors. In the Amnesty International report, they actually surveyed the various countries around the world that we compare ourselves to, and 65% of those countries, the maximum penalty allowed by law for kids is 20 years.
Did they survey the states of the United States?
In the states of the United States, as we...
4 states permit life without parole?
That is true, but in fact, if you look at the trend is going in the other direction. And if you look at what's happening now, I think in my brief I talked about 12 states no longer impose it, or if they have it on the books, they haven't imposed it. It's right now our closest neighbors, Maine and Vermont, they have it on the books, no juveniles serving the sentence. New York and New Jersey, they have juvenile crime at twice the rate that we have it. They have life without parole on the books. They have no juveniles serving that sentence. So although many states have it on the books, in fact, the trend is not to impose it on the juvenile. That is the situation, that is the trend as to where we're going in the future. Although the Commonwealth's briefs talk about the fact that, in fact, we're going in the opposite direction, we're really not interested in reducing penalties for juveniles. In fact, if you look at what's happening across this country in the legislation, in fact, the trend is to reduce the penalties for juveniles, because there has been this huge increase in knowledge about child development, adolescent development, brain development that actually says the brain doesn't reach full maturity till the age of 25. We are in a process of learning a lot more about how kids think and act, and what we all know as parents, going back to what was said, is that kids act before they think. But when we're talking about punishing juveniles, what is the point of just throwing away the key? Life without parole is nothing more than a death sentence without an execution date. We're sentencing them to die in prison. And the problem with just the answer of parole is that, first of all, we have a separation of power issue. You know, the parole board is an executive branch. They don't make sentencing or resentencing decisions. And if we look at the issue of parole, in contrast to what the AG's office said, in fact, when we reviewed all of the decisions that had been made, other than the last two they quote, the factors that they look at do not even begin to resemble the Miller factors at all. And if you look at what's happening with the parole board as applied to juveniles, it's not only that parole is uncertain, it's in fact unlikely if you were a juvenile at the time of the crime. Parole board seems to look at the fact that you were a juvenile at the time as an aggravating factor rather than a mitigating factor. They also highlight recidivism, ignoring all of the data that we all know about recidivism. In fact, that this court actually quoted in your O'Neill decision that, in fact, homicide has the lowest recidivism rate. And if you look at footnote 17 in my brief, I actually point to a study out of California that shows that homicide recidivism rate is less than 1% now. You know, we had a period of time in 1992 to 1996 where, in fact, we had special sentencing for juveniles. That was the period of time where, in fact, prior to the change in law in 1992, we had this sort of draconian choice. A kid was basically found guilty of murder, and they were sentenced to DYS to 18, or they were transferred to the adult court and sentenced to die in prison. And everyone knew that was an inequitable choice. It made no sense. The legislature looked at it and very carefully, after some careful consideration, imposed the 20-year max. Okay, and they were eligible for parole after 15 years, 20-year max. We have data on those kids. And, you know, there were 33 kids held in DYS during that time period from 1992 to 1996. And of that cohort, Dr. Frankie Di Cataldo actually was working for DYS at the time. He did a study on those kids at that time. He published it in 2008, and he's now in the process of doing follow-up to see, you know, what happened to those kids that got out after 20 years. And what's so interesting about that cohort is that, in fact, those that have gotten out, there were, of the 33 that he studied, 8 were transferred, so they are serving life without parole. 2 were found not guilty. We have a cohort of 23. 10 were basically sentenced to the 20 years. 8 of the 10 are serving for second degree. None of them have been granted parole, consistent with all the data that we've reported in Attorney Keene's brief and mine. They have not gotten out, even though they're all just hitting their 20-year mark.
But let me get back to what I understand to be the essence of the argument. Is it your contention that under Miller, under the 8th Amendment to the United States Constitution, it is prohibited for a judge, or prohibited for there to be a law which mandates life with the possibility of parole?
No, I'm not saying that. I'm saying that the problem is we don't have a statutory scheme here that would allow you to do it, and unless you...
I thought you were saying you could not have a law that mandated.
Oh, I'm sorry, I didn't hear the word mandated.
Is your view that Miller says there may be, that it is unconstitutional for a state to pass a law which mandates life with the possibility of parole for murder 1?
If that is the only penalty allowed by the law, I would say that would be unconstitutional.
And is there any state that has interpreted Miller that way?
Not to my knowledge, because I don't think the issue has been confronted in the same way that our statute provides, or that any statute provides. Most of the states on their first degree have a range of sentencing options, even up to, you know, various terms of years included in their statutory scheme. I don't know of any state that's done this, and I don't know of any state that has as narrow a statutory scheme as ours. And basically what we're saying here is that we don't have the statute that we can work with. And if the legislature basically passed a law that said juveniles were subject to mandatory sentence of life with parole, I would be back here saying it's unconstitutional, yes.
And it would be unconstitutional under the 8th Amendment or unconstitutional under Article 26 of our Constitution?
I'd probably be trying both. basically, the reality is, I think if you cannot take into account the individual characteristics of the juvenile offender, the statutory scheme is fatally flawed, as Justice Kagan said. And any mandatory sentence, one choice, that's it, doesn't take into the characteristics of the youth, doesn't take in the diminished culpability, doesn't take into account the capacity for rehabilitation. What does it give us? It gives us no sentencing discretion.
So life without the possibility of parole, then you say, is a necessary component of the scheme. If you had life without the possibility of parole and life with the possibility of parole, then you have two different sentences that can be imposed.
I'm certainly not saying that.
I didn't think so.
Under Article 26, I would really argue that under this court looked in Watson at the death penalty, and the death penalty was declared constitutional under the Eighth Amendment. This court looked at the death penalty under Article 26 and said it was impermissibly cruel because it was arbitrarily inflicted, and it basically did not conform to the evolving standards of decency of a maturing society. All of those
So
factors
you're
apply.
saying, I take it then that you're saying, I want to make sure I understand this.
Okay.
You're saying, I think, that the only acceptable punishment for murder is life or any term of years.
I'm not saying that specifically. I'm saying the
Well,
legislature...
life or a minimum of 5 years. Could
I'm
that
s- I-
survive?
I'm saying that the legislature can draft a statutory scheme that provides a range of sentences. It could actually even include life without parole. But if life without parole remains on the table, then it becomes the Commonwealth's burden to prove that this is the incorrigible, rare, uncommon juvenile.
But you're saying, at least I think I'm hearing you say, that there can be no floor except 0. The only acceptable constitutional floor on a murder conviction is 0. 0 up to life in prison. You can't have a 5-year minimum mandatory for life, in your view.
I think the legislature can do a lot of different things.
But that's not my question.
A mandatory minimum of 5 years, a mandatory minimum of 0. I think that the mandatory
Well,
minimum...
there's
is
no
the
minimum mandatory
I
of
mean,
0. You don't
there's-
get a prize
right.
for killing somebody.
There's no mandatory. I think when you have one sentence as a mandatory sentence, I mean, it's a hypothetical that really doesn't resonate as making sense to me, but basically, if it's the mandatory sentence and that's all that's allowed, under Miller, I think it doesn't provide the discretion.
Could I ask one final question, Chief? Sure. You cite to the International Covenant on Civil and Political Rights, of which the U.S. is a signatory, as being one of the international covenants violated by life without parole. What covenant, what article under that covenant is violated?
I will have to look it up and give you that response. I don't know it off the top of my head. But
I don't see it, so I'm just curious.
I will be happy to provide the answer in a letter to the court.
Thank you.
Thank you, counsel. We'll take a brief recess.